Okay, and I'm gonna let everyone in. Starting the webinar. Let everyone in. Starting the webinar.
All right, welcome everyone as we are getting ready to start this important legal forum today. We are waiting for people to come in, so we're going to give a couple minutes to welcome people in, giving people time to come in before we start this webinar. I would note that we do have a lot of speakers today so that you can get all the information that you need to get. So we are making sure that we give some time. I do want to note that this is a webinar, and because of a webinar, we ask you to put all of your question and answers in the question and answer section Q&A. After each speaker, I have my staff that will go through that question and answer to see what has been asked, and we will then make sure that if it's general questions, that we will send a notice to the I will be the one asking the questions openly, but you're welcome to put question and answer in the chat. Each of the speakers can see your question in the question and answer section, and they also have staff that can respond to those question and answers. So we definitely thank you all so much for coming. We do appreciate Attorney General Anthony Brown, who has been very busy on our behalf for the state of Maryland. And we want to make sure we're going to start soon because he can't be on here very long. But we wanted to give some time for people to come in. So we will be starting in 1 minute. Just note that this is being recorded. So if anybody needs to go and actually see it, you can find it on my YouTube channel. We are streaming it there also. So you will be able to ask questions. You can also get that if you want to keep that for reference. All of the the presentations of today, we will gather them from the speakers, and any resource information that they provide today, we do plan on emailing that out to anybody who signed up. But we are limiting that to those who signed up, so we want to make sure people sign up. Make sure you sign up, and if you didn't sign up and maybe this link was forwarded to you by a friend, to make sure you email our office to let us know if you want to make sure that you get the information. And my staff will put the information of the of our office in the chat so that you all can actually see, so you can have access to our information for the office. And with that, I think we are at 6:05, and as we have a busy, a very busy agenda for today. We're going to go ahead and get started. And I just want to open up by saying that this is one of the second series of these that we have. We do understand, even though we have realized that a lot of people are signing up from our events from all over the state to get information, we do recognize that I am a representative in Prince George's County, and over 73,000 federal workers live in Prince George's County. So we are definitely have one of the second largest number of federal workers in the state. And in fact, as you can see from the reviews of many of the journalists that articles are coming out, the federal government really changed the makeup of Prince George's County, and the history behind it has been set due to the federal government hiring. So the slash of federal government workers has a huge impact on us. We have even larger group of federal contractors. Also, I would note that today is more for just definitely federal workers, but we will have something for federal contractors in the future. Because of that, we are very concerned. The county is very concerned. We will provide as much resources as possible. Some of you were here on the last meeting we had with Congressman Hoyer, and some of the concerns were more about legal issues than focusing on some of the political discussion about legislation, which is quite depressing for right now. But at the same time, we listened and we got a lot of feedback from people that they wanted to hear from lawyers. So today we're going to start with Attorney General Anthony Brown, who is going to talk about overall litigation. The state of Maryland, through legislation, has provided legislation that gives the authority of the Attorney General to defend us when it comes to many of the issues that we're facing here. There has been some litigation to protect federal workers on behalf of federal workers. So we definitely will hear from him on that. And then we have a representative from American Federation of Government Employees, one of the largest unions for federal workers. And they're going to talk about what they have been doing on behalf of the federal workers. Now, I would note that they actually, if you remember, they came to the last meeting that we put together. And during that meeting, they were very open about the fact that they were doing legislation. But many people ask what is going on the litigation side. So we had to overview them, but now we do have the general counsel for AFGE, Rashab, who's going to be coming on. And then finally, we're going to end this with Tom Gagliardo, who I've known for years, and he is a federal worker attorney, and he's going to talk about what you can do if you are a federal worker attorney looking for assistance and seeing what options you have. So let's get started with Attorney General Anthony Brown, and we're going to bring him up, and he is going to talk about what they're doing at the federal level. So let's bring Attorney General Brown up. All right. Thank you so much for fighting on our behalf.
Councilwoman Legay Walla, my good friend, thank you for inviting me to speak this evening about what we're doing in the Office of the Attorney General in response to the Trump administration. I need to start by saying, the Office of the Attorney General, I've got 700 lawyers. The General Assembly and the governor gave me resources to establish a federal litigation unit, and that's what I have to defend and protect the interests of the state of Maryland and the people of Maryland. I do want to say, and I think you alluded to it, Walla, the General Assembly gave the Office of the Attorney General authority in 2017 to bring lawsuits. But it's important to point out that doesn't mean we can bring any suit and every suit to protect the rights of Marylanders, right? We can protect the interests of the state of Maryland, and we can talk a little bit about what that means. But just to kind of put some numbers behind it, there have been over 170 lawsuits filed against the Trump administration. The attorneys general, that's me and a coalition of about 22 other AGs around the country, we're involved in about 11 of them. We've got to always determine, do we have standing on behalf of our states to be able to bring in action? So I want to talk to you a little bit about some of the actions, roughly a dozen lawsuits that Maryland has brought or joined against President Trump, the administration, since January 20th. And I should start by saying that the lawsuits, what we seek to do is, things like protecting birthright citizenship, right, which is enshrined in the Constitution, keeping Marylanders' personal information safe from Doge and Elon Musk, who parachuted into this large payment system, and also unfreeze federal funding that our state relies on to serve Marylanders. And tonight, I'm going to talk briefly about federal workers. And as Walla mentioned, there are, in Maryland, and the numbers are, these aren't the exact numbers. I'm not the authoritative source, but there are about 150,000 federal civilian employees representing 5% of our state's workforce. I've heard that number even higher, or that percentage even higher. Here in Prince George's County, I think it's around 30,000 of our neighbors work for the federal government, and Councilwoman Legay mentioned the federal contractors. And these are hardworking public servants, civil servants mostly, whose lives and livelihoods are under threat because of the Trump administration's war on the federal government and federal government employees. So I'm going to talk just a few minutes about our ongoing lawsuits that we're involved in defending federal employees and your jobs. One of our most recent suits, which we filed on April 4th, seeks to stop the dismantling of 3 agencies: the Institute of Museum and Library Services, the Minority Business Development Agency, and the Federal Mediation and Conciliation Service. We filed this lawsuit because an executive order would have dismantled these federal agencies that were created by Congress that collectively provide hundreds of millions of dollars for programs in Maryland and every state. And because of this mandate, particularly on the museums and libraries, they began cutting hundreds of grants for state libraries and museums, and that placed almost its entire staff on administrative leave. Meanwhile, the Trump administration cut the staff of the Minority Business Development Agency from 40 employees to just 5 people. And this agency has effectively stopped issuing new grants, hurting vulnerable small and minority-owned businesses, women-owned businesses across our state. And these are grants that Maryland small businesses rely on. In 2024, MBDA projects supported entrepreneurship education for many small business owners, including, for example, incarcerated people in programs at minority colleges, or HBCUs. I recently spoke with a woman business owner in Hyattsville. She was counting on an MBDA grant to hire 10 new employees this spring. And without that funding, she's had to cancel her expansion plans and may need to lay off 3 current employees. So these are the real impacts. These are essential services that are now in jeopardy because the president decided to eliminate jobs from these critical federal agencies. We all know those aren't the only federal workers whose jobs are currently at risk. On March 13th, our office sued over the president's reduction in force order that is alleged to be the first step in the unilateral dismantling of the Department of Education. President Trump announced the department would be firing approximately 50% of its workforce as part of achieving its goal of what he called a total shutdown. And that dismantlement threatens to strip Maryland schools of critical resources that our schools rely on to educate our children. It would also mean tens of thousands of federal employees would lose their jobs, including many right here in Prince George's County, where federal employment is a cornerstone of our middle class. So our office did not stand by idle. As the Trump administration set out to dismantle these departments and these essential government services and agencies, so we filed a lawsuit. The last lawsuit that I want to mention, then perhaps more will come up in the Q&A or the discussion, is our case against the Trump administration for firing thousands, 23 to 24,000 federal probationary employees. And these aren't just new employees. These are employees who may have been working for the federal government for many years, but when they got promoted, they went back into probationary employee status. So the administration claimed that they fired these employees for poor work performance, despite the fact that many had recently received glowing assessments just months prior. So this was clearly a coordinated effort to eliminate the federal workforce, even if it meant breaking the law. These sudden mass layoffs forced hardworking civil servants and their families into financial insecurity, a sudden and unexpected crisis that risks overwhelming our state's ability to help the unemployed and to connect these employees to employment services. Last week, I met a single mother of 3 in Largo who worked at the Department of Education for 8 years. And after losing her job without warning, she now faces the impossible choice between, paying her mortgage or making choices between a lot of other necessary expenses. And I also spoke with a veteran, a Navy veteran. Now I'm Army, but he's a Navy veteran, and we're fighting for everybody, from Fort Washington. And he dedicated 12 years to improving veterans' health care while working at the VA after serving in the Navy. And after losing his job in this latest purge, he's depleted his savings, as he described to me, and he risks losing the very home that he has been raising his family in. So our office quickly filed a lawsuit on behalf of Marylanders like these dedicated public servants. We won a preliminary injunction in this case, which required the administration to discontinue the layoffs. It ordered them to reinstate the probationary employees. Unfortunately, last week, the Fourth Circuit said that the Trump administration does not need to reinstate. They can no longer lay off. They don't have to reinstate. Some have already been reinstated. So we stay on the front lines on that fight to ensure that Marylanders continue providing for their families. Let me just wrap up by saying that, to all the federal employees on this forum, my office and I, we understand the insecurities that this administration has inflicted on you. Many of you have lost your jobs. Many of you are concerned that may be in the not too distant future. We understand that, you may very well feel disillusioned and certainly disrespected by an administration that doesn't see the value in your work. But I want you to know that the Office of the Attorney General, we are on watch. We are bringing actions. We are here to fight for Maryland and Marylanders. So, the 5% of you, right, who make up Maryland's workforce in the federal government, we understand that these attacks impact not just you as individuals, but our entire community. So we'll continue the good fight. And again, I want to thank Councilwoman Blagay for letting me participating in this evening's webinar.
Thank you so much. And I do want to ask just a couple of questions that people would know. Now, some people have some individual cases of termination or being laid off, and they would like to reach out to your office. How are you all handling individual cases? Can you give some guidance on that for those that are coming here to just sort of seek assistance from your office?
Right. So, and thank you for the question. I know that, and you had mentioned that you've got one or two lawyers from labor unions. My advice, and this was ever since the fork in the road offer was made to federal government employees who were, encouraged to take an early out. I said then, and I say today, the best thing that you can do is talk to a representative in a labor union, AFGE, FSME, NTEU, whatever bargaining unit represents your workplace. Speak with them. They are the pros. They're professionals on federal personnel law. And that's for current employees. When you're separated, what rights and benefits may be available to you. The Office of the Attorney General, there are a lot of things that we do well, a lot of things that we specialize in, but we don't have the authority, so therefore we don't have the specialization in the area of federal personnel law. But you've got the right people on this webinar tonight, Councilwoman Blagay, who can speak directly to some of those questions. Now, having said that, you can always reach out to my Consumer Protection Division, because that's sort of the portal into the Office of the Attorney General. And if we can help connect you to our colleagues at the Department of Labor for employment services, our colleagues at the Department of Labor for unemployment insurance benefits, their websites are available as well. But if you're having difficulty and you want to reach out to us at the Maryland Attorney General's Office, Consumer Protection, we'll connect you to the right resources in state government.
And thank you for that. So that goes for a lot of people. We definitely have people who want to get that. Can you tell them how they can get in touch with your office, what information, and it would be great if your staff could post that in the chat so that people will know how to get in touch with you. But right, can you just list that out?
Mm-hmm. Yep, and I have a staff member who can do that. And fortunately, because of the powerful search engines, if you put in Maryland Attorney General, you're going to get our splash page, and you're going to see a link. One is going to say, I think, federal actions and response. You can click on that, see the resources that we make available. You'll also see links to my Consumer Protection Division. Again, I understand that your issue might not be traditional consumer protection, but if you go there and you fill out the information there, we can direct you to where you need to go. And I see someone just pulled something in the chat for me.
Thank you.
Xavier did. Okay, Xavier, thank you.
Thank you so much. Now, there are people who, they said someone from NASA said they just received notice that not NASA might close. So for those who are kind of in a waiting mode, can you give them a guidance on how your office is going to handle future lawsuits if they are facing possible mass layoffs at their agency?
Sure. So, and it gives me an opportunity to explain when we have, and you heard me say standing. I know we have some lawyers and non-lawyers on the webinar, so I'm going to speak in lay terms. When the federal government does a mass layoff or reduction in force, under federal law, not state law, under federal law, they are required to notify states. Right? Why? Because Congress recognized long ago that these mass layoffs can disrupt communities. So the federal government is required to let us know. They're also required to do a number of other things, right? Give preference to veterans, right? Give preference to seniority. So there are mechanisms in place that they have to follow, procedures which protect the workers, and it also gives the state information. Why does the state need information? So we can identify who those employees are, connect them to employment services, can begin the unemployment benefits verification process, because we've seen in these mass layoffs that the administration will say, oh, it's for cause, yet there was no cause whatsoever justified. And in order to get unemployment insurance benefits, for the most part, generally, it can't be a for-cause termination. So that's why they're required to give us a heads up so we can identify the workers, begin working with these workers to see what benefits are available to them. So at NASA, if they're doing a mass layoff, which under the law, it's 50 people or more, and they don't have to all be in the same office, but if NASA is laying off 50 people or more, there's a requirement. So please reach out to us and let us know that you got that notice so we are aware of what the federal government is trying to do in different workplaces, different work sites, different agencies.
And thank you so much. That goes, we did, Tommy, I did see your email. It's good to know. If you all know that something is coming, you should possibly give a notice to the Attorney General's office, and they would look for, because he is right. In order for you to file a lawsuit, you do need standing, and they have to look for standing because standing will give you, as someone being fired, you might have standing, but the Attorney General is not a party until they can find a way to be a party, and then that's where the state law helps them out, becoming a party so that they can file a lawsuit. So, and actually, can you just give a notice on the status of the case for the probationary employees? Because there are a lot of them on here that just want to get clarification as to where that litigation is.
Sure. So we filed the litigation maybe 4 weeks ago, maybe a little bit longer. We were successful in getting a temporary restraining order where the judge said, Judge Badar here in Baltimore said, stop, Trump administration. You cannot lay off these probationary employees. And in fact, said you've got to reinstate them. And we were getting pretty good, a sense that there was pretty good compliance on the reinstatement. Some were actually returning to the workplace. Some were on paid administrative leave. The DOJ appealed that stay for the reinstatement to the Fourth Circuit. And the Fourth Circuit said, yep, we're not going to require reinstatement. And the case continues. It's still in district court. The administration cannot continue to lay off probation employees, not as a RIF. Now, I want to make clear that doesn't prevent the president or an agency head or a supervisor to terminate someone as part of the performance evaluation process. If you're a contract employee and the contract term is up, what they can't do under our case is a mass termination, 50 or more, layoffs under some guise of restructuring, reorganizing, or just simple reduction in force. That they cannot do.
Okay, and thank you for that. I did want to know, and we do have Tom that's going to outline that, but there is a difference. Now, they do have to go through a process if they terminate you for cause. So that should be more individual, meaning that there would be, so it's different from the massive layoff, which is more reduction in force. Now, I would say that a resignation would not apply to probationary. So just be careful of those who are entertaining any type of resignation or accepting any type of buyout. That does sort of take you out of anything that happens. Now, I think that the Attorney General, we do have him for a couple more minutes. And just note, Attorney General, do you think, no, because of these cases are pending before the Fourth Circuit and things like that, can you explain, because many people are saying, are we going to receive back pay, things like that? Can you give a forecast of sort of what happens if we win or lose?
So, and that's a great question because, like, when you think about temporary restraining orders and preliminary injunction, that's during the course of the litigation. Okay. And when we get that temporary restraining order, when we get that preliminary injunction, and for the most part, if we were to get a final judgment in favor of the states, which would then benefit the workers, you return to the status quo that existed before the action was filed. So that should include back pay, but you can rest assured that DOJ is going to be arguing the contrary, and that's my sense that they will argue against back pay. So it's not, it'll be something that'll be litigated, and the position that we take is you have to return everyone to the place they were before the unlawful action was taken by the president. So that would be back to the point where you were employed and being paid, take you back there and pay you going forward. So that would be back pay. That's our argument, our position that we would take. And then the administration, the DOJ will take a different position. But we think we have strong arguments for back pay.
And just know these things, in order for you to receive back pay, they have to exhaust all the remedies. So meaning that if there is any appeal, everything is on hold until there is a final decision. So just that everyone knows that even if the Attorney General, let's just say they win the Fourth Circuit, if they decide to request to go before the Supreme Court, then everything is on hold until the Supreme Court makes a decision or decides not to make a decision. And just finally, I would say, is there any other future things that you could see? I think some people are talking about mortgage, maybe even a hold on mortgage. I know there's a limitation that the Attorney General can do versus the legislature. Can you just give an overall of just things that you all might consider, but maybe the legislature has to do it instead of the Attorney General's office? And the mortgage thing came up. I would know that for anyone, mortgage is more on the state and federal level, so it's definitely not local. But I don't know if the Attorney General can have any impact on that.
I mean, the answer to any question about what the Attorney General can do is the question is, does that action which harms people? So if I'm not quite sure what the question is around mortgages and what, yeah. You want to clarify?
And let me just clarify, because I do know that this has come up to the county level. There even has been legislation that, much like during COVID, that mortgage forgiveness or something that was that came through the federal will come, or maybe even requiring mortgage those that are giving mortgages to give some sort of lax or help if someone is is behind on their mortgage. Now that's something that maybe they can look at the state level, but that really will come from the feds.
Yeah, thanks for the clarification, because I think, like you said, COVID's an example, but mostly the Fed, to a lesser extent, the state government had some assistance programs. The sad reality is, under this administration and this Congress, the likelihood of mortgage assistance is low. I don't see this Congress making that kind of appropriation, and I don't see this president finding resources, federal dollars, to assist mortgage holders who are having difficulty paying the mortgage if they're terminated from federal employment or any other purpose, quite frankly.
All right. Well, thank you so much. Devin, do you see anything else? I think we've gotten most of it. But if you
Yeah,
someone's,
just one additional one.
Mhm.
I think we got this one actually. I'll take care of this one about weatherization offline.
Yeah, we can, we do that. I would say somebody didn't know that, I think those in the IRS are, in the process of being, laid off. Make sure you let the Attorney General's office know so that they can keep eye on that. It does look like, a couple of people, and then they said Treasury too. So just a note for you, Attorney General, that looks like there is going to be a massive rift at Treasury for those that are working at Treasury. And we also see a note about something at the IRS, and we've heard someone say something about NASA too.
Thanks for bringing that to my attention. I will certainly circle back with my Federal Accountability Unit to make sure that they're on our radar. And some of those organizations may already be in the probationary employee lawsuit.
That's right.
And I don't know if the constituent that put that in the chat is probationary or not, but the requirements around RIF apply probationary and tenured or a permanent employee. So we've got that Treasury, NASA, and the IRS.
Okay, so we would know that. And I would say we don't know. I think people don't know what mass firing is because they might be letting go a couple of people. So we do want it will be good to know whether it is a massive thing or not. It would have to be, I would say the Attorney General would have to do something more with executive orders and more large scale decision making, which will give him standing.
Typically, what we look at are, like you said, those executive orders, the letters that come from OPM, or now that the administration is getting settled into agencies, an announcement from a hiring official, a cabinet secretary, an agency secretary. So certainly, if anyone who has put in, whether it's IRS, Treasury, NASA, if you have one of those notices, then please send that to us as well.
All right. Well, thank you so much, Attorney General. I would ask your staff if they can once again post the information in the chat. And then we will go from there. Thank you so much for this. We will want to someone did say something about FDA. So we definitely will pull that because we do know that that's even based in the state of Maryland.
And let me just say one thing as I'm kind of departing, and this is really an expression of gratitude to federal government workers. I'm always troubled. I'm deeply troubled when I hear people say, "Oh, Maryland, it's over-relied on the federal government and its economy, where 1 in 10, 1 in 5, whatever that number is, 5%, 10% of our workforce are federal employees." This is us stepping up. Right, the federal government, provides invaluable services. Right, at USDA inspecting our food supply. IRS making sure that we get back timely refunds. I mean, it goes on, and this is Marylanders, this is Prince Georgians who have stepped up to answer the call to serve in federal government, to serve the people of our country. And it bothers me when our president turns around and treats us just like numbers. Oh, you've relied too much, Maryland, on the federal government. The federal government's too bloated. The federal government's not too bloated. The federal government has people, men and women, who are doing great work on behalf of the people of this country. So I thank you and I salute you for that work, and we're here to fight for you.
Thank you so much. And I do appreciate you. And we do appreciate you. And we just ask, keep fighting. The staff will put the information. If you have a notice or something grand that you can give him, understand that's what the Attorney General needs to move forward. So thank you so much, Attorney General, for your work. And we are definitely looking forward to working with you. And we will bring you back later on if there's any other updates. Thank you.
Take care now.
All right. Next, we are going to have AFGE come up. Rashab, which is with AFGE. AFGE is one of the largest unions that has almost 1 million fellow workers they represent. So let's get Rashab up, and we are going to have him talk about what they're doing at AFGE to protect workers.
Thank you all, and thank you all for having me here today. Yes. So most of you probably already know what AFGE is. AFGE is the largest union representing federal employees. As well as said, we represent over 800,000 federal employees all over the federal government, everywhere from we have some units at NASA, we have many units at the VA. We represent pretty much every agency you can think of. I heard that we had a speaker at the last town hall that Walla had organized, talking about our legislative efforts. So I won't go over too much about that. But before I go into sort of litigation, which is what I'm here to talk about, I just wanted to sort of set the broader stage, which is that at AFGE, we are fighting for all federal workers, not just our members, and we're doing that in many ways. Litigation is important, but as a union, we think the most important thing is solidarity, standing together. And this is federal workers and the communities that they serve standing together, no matter where that is. Well, that in Maryland, in Nebraska, in California, wherever we are. And we continue to sort of push the message, which is the truth of how important what you do, what federal workers do is to everyday, to Americans in their everyday lives. And so it's important, again, to recognize that AFG is here not only to fight for you in the courts and at the agencies and on the Hill, but also to highlight the importance of what federal employees do, and highlight how federal employees are coming together to fight for themselves, but also to fight for all Americans. Because when you are a federal employee, and I know this from talking to federal employees every day, your job is not just a job. It's called public service for a reason, right? You're in this to serve the public. Your job is to help America be the great country it is. So that aside, what are we doing on the legal front? We have several lawsuits against the administration. If you look at a list of plaintiffs against the Trump administration, AFG is probably near the top. Working alongside the state governments and the AG's offices, who provided a lot of assistance to federal employees. We're pursuing many different angles. I think the case that many of you have heard about, which is sort of an analog to the AG's case, is about probationary employees. And so, shortly before the state attorney generals filed their case and challenging the Trump administration's termination of tens of thousands of probationary employees, AFG, along with our other union partners, AFSCME, filed a lawsuit, and we built a coalition of nonprofit plaintiffs to argue that the termination of these probationary employees was unlawful and was based on we actually said in lawsuit it was based on it was a scam. It was based on faulty premises, because as you all are aware, and I won't get into too many details, when these employees were terminated, they were all terminated based on a template that said it was for performance reasons, despite the fact that most of these employees, if not all of them, had satisfactory or better employment. So our case has gone through a bunch of twists and turns, but we did get a preliminary injunction, a nationwide preliminary injunction. At first, that preliminary injunction applied only to OPM, and it said, OPM, you can't direct these unlawful firings. It was expanded, however, to include several agencies, including the Department of Veterans Affairs, the Department of Defense, the Department of Interior, USDA, and others. As a result of the lawsuit, probation employees all over the country were reinstated. One key distinction with our lawsuit and the lawsuit by the state attorney generals is because of a different legal theory and the different showing of harm, the judge in our case had directed the government not only to reinstate employees for pay purposes, but to reinstate them to their jobs. Because, one of the things the lawsuit highlighted was, and this is how we showed harm in that lawsuit, is that when you fire probationary employees like this, you're cutting services to the government. I mean, to Americans. And one of the examples the judge pointed out was by firing the locksmiths at the Department of Interior, you shut down national parks. The case also highlighted the termination of probationary employees at the Veterans Crisis centers, which increased wait times at these centers. And so the judge had ordered the government not only to reinstate these employees to being paid on administrative leave, but to actually put them back in their jobs. And so the case proceeded. The judge's order was limited for a lot of technical reasons to the claims made by the nonprofit plaintiffs that the union had created a coalition with. But the judge had initially said the unions didn't have standing to file the lawsuit. So that'll be important in a second. And so, as expected, the government appealed the judge's order while it started reinstating employees, and so many employees were reinstated, many with back pay. And then the Ninth Circuit Court of Appeals, which is the Court of Appeals that reviews appeals from courts in California, among other states, and California is where we filed the lawsuit. The Ninth Circuit Court of Appeals declined the government's request to stay or to pause the injunction or the order. And then the government appealed it to the Supreme Court. And then last week, unfortunately, the Supreme Court, in a narrow decision, decided to grant the government's stay, saying essentially pausing the judge's order of reinstatement. Interestingly enough, however, the Supreme Court made it clear in their decision that their decision only applied to these nonprofit plaintiffs who had made these claims. So during sort of this long litigation process, the judge at the district court, at the lower court, had changed his mind about his ability to hear the claims made by the unions. And so in an interesting twist, the day after the Supreme Court's decision pausing the judge's order, the judge had a hearing on whether or not to grant another preliminary injunction or expand the preliminary injunction to include the union's claims. And that hearing happened last week, and we expect a decision anytime soon. And we're hoping the judge will grant that request for preliminary injunction and expand the relief to every agency where the union, either AFSCME or AFG, which are the two primary unions in the case, represent federal employees. Again, we don't know what the judge will do at this point, but that's kind of where the case is. And so there's a possibility that any day we will get an injunction back in place to prevent the federal government from either re-terminating these probationary employees or sort of to force the government to continue to reinstate these probationary employees. So that's one case that's out there. There's several other cases. I'll go over just two. I'll go over one more big case for the union, which affects all federal employees, even though it's just against the union, against unions, and that involves an executive order that was issued a few weeks ago by the president, which strips collective bargaining from several agencies. Basically, the president is claiming to use an exception to our collective bargaining statute to say that all of these various different agencies are not allowed to have union contracts because of national security. We believe it's pretty clear that the president, just like he did with the law firms, is using this to retaliate against us because we've been outspoken against the administration. The president's rhetoric with the executive order confirmed that. If you look at the fact sheet, for instance, that he issued with the executive order, he says, he's going to work with unions that work with him and that he doesn't like unions that attack his agenda. So we filed a lawsuit on this, and we hope that's going to be successful. That's taking place in the courts. I just want to highlight, again, sort of why, I think it's important to realize why the president is going after unions. And that's because of, and this is not just AFG, this is, all of the various federal sector unions and all of the private sector unions as well. It's because the president knows that we are one of the best. We are at the front of the fight, and we are delaying or forcing him to stop with his actions. And so he knows that we will succeed, or we will try to succeed in stopping his dismantling of the federal government. And so now he's coming after us. Again, we're not scared. We are continuing to fight, and we're fighting that executive order. If you do know, however, any friends, family, or if you are eligible to be an AFG member, or a member of any other federal sector union, or any union at all for that matter, it's important that you continue to sign up. And that's not only because there's the dues payments fund some of this litigation and fund our efforts to stop the administration, but also because by signing up, you increase our membership numbers and membership numbers of unions as a whole, which again provides fuel to the movement, which shows that we are not going to back down. So there's been some questions about RIFs, so I wanted to talk about that a little bit. So there's various different ways the administration has been trying to dismantle agencies. In some cases, and the Voice of America is one example, as well as USAID, slightly different. But the administration has essentially been trying to try to sort of wholesale get rid of an agency. In both of those cases, we've been part of coalitions to try and stop the administration. With USAID, we initially, with the help of a nonprofit called Public Citizen, who is litigating that case for us, we initially were able to get a stay from a judge in DC to stay the TRO rather to stay the administration from placing everyone on administrative leave and conducting reductions in force. The judge in that case dissolved that TRO, but we continue to pursue that case, and we've recently briefed our motion for summary judgment, and we hope to be successful in stopping sort of the wholesale dismantling of USAID. We continue to take other actions as well, either before the MSPB or in the grievance procedure on that. Another one is the Voice of America. It's also called the U.S. Agency for Global Media. AFG, along with AFSCME, built a coalition to stop the Trump administration's, through Kari Lake, their dismantling of that agency. We have a TRO in place on that we were able to get with the help of a couple of different law firms, and we are going to hopefully expand that to a preliminary injunction, which would be a longer stay, again preventing or hoping to prevent the agency from engaging in mass rifts at that agency. So those are two examples. We're also developing ways. You may know that in the next few days, agencies were required to send the administration sort of plans for reorganization, reduction in force, and moves of agencies. We are planning with various partners to initiate litigation on those issues. We're still in the planning phases, but we are going to be out front on that. And then finally, again, just wanting to talk about everything else the union does. If you are a union member, an AFG member, feel free to contact your local affiliate or our national office. We are assisting several different of our units at different agencies with, MSPB appeals on reductions in force, grievances on those same issues, and helping with sort of the day-to-day that's happening at those agencies. And we're only able to do this again, not only because of, the amazing partners like the state of Maryland and the other state attorney generals, as well as, Public Citizen and State Democracy Defenders and Democracy Forward, but also because of our members who are the reason for the fight, right? They are the ones, who are coming together and forming this union because, I'm just a staff member. The union is composed of federal employees who want to take this fight, to the administration for Americans and for their coworkers. So that's my sort of overview of what AFG is doing on the legal front.
Okay, just a couple follow-up questions. Number one, people would like to know, where is your membership? Because there's a couple people who are basically wanting to know, are they in the union? If they're not, how can they join the union? We had someone that might be, there are people who work in various agencies. So can you go over what your membership is?
Yeah, so like I said, AFG represents employees all over the federal government. So the best place to go would be to go to www.afge.org. There are different links there where you can find out what your local affiliate is and who, whether or not we represent you. We represent most of the employees at the Department of Veterans Affairs. We probably have most Department of Defense employees who are in collective bargaining units. In the DC area, some of the biggest units we have are, Department of Defense, Defense Health Agency, the National Archives and Records Administration, FERC. We also represent many DC government agencies as well. But again, it's if you're a federal employee, there's a 75% chance that AFGE is your union. If you do work for the IRS or CFPB,
NTU.
those are NTU, and we work closely with NTU as well. They're also one of our partners, and they're fighting this fight with us. So those are the two. There's a couple of other federal sector unions, NEFI and NAGE, but you would likely know if you're in one of those units.
Right. So, AFGE is probably the largest, and most of you probably are in it, except for the money agencies, IRS, CFPB, Treasury. Those are in NTU. So we will do that. But do you have someone in your team that can post the website that people can check it out? Also, Rashad, can you tell, is there any of the litigation that is sort of putting anybody back to work right now, or is everything still in limbo?
Well, so the litigation we had with respect to the probationary employees, that did result in the reinstatement of several employees. Not several, thousands of employees. And in most cases, not all, but in most cases, it resulted in back pay. There are some other lawsuits we have out there. So, for instance, the Voice of America lawsuit resulted in it essentially stopped the agency from expediting reductions in force. We also are part of a coalition of unions that are filing a lawsuit at the FMCS. I think it was filed earlier today. And then, again, we plan on doing some reduction in force lawsuits. We're looking very closely at what's happening at NIH and HHS more broadly. But again, there's a lot going out there. And I think, our goal when we can litigate in a way that would result in reinstatement for someone who's fired or in many cases, delaying or preventing a reduction in force. That's our goal, right? Our goal is to protect federal employees so they can continue to serve.
And let me just ask this, because someone's going to say, well, I'm a temporary employee and they haven't called me back. So is there a reason why everyone hasn't been called back? Do you know? And if no one's reached out to them, is it because they have not been called back?
The probationary employees. So, at most agencies they were. If they haven't been, I think the best course of action would be to contact their local affiliate, and we can look into that.
Okay, so and we would just ask you to reach out because some people have said that they have not heard anything. And is there and then also, if someone is not in the union, will they benefit from any of the litigation? Is your litigation sort of, so people can understand that it's broad litigation for everybody as opposed to just union members?
Yeah, and I think all of our so for instance our probationary employee case, right? It covered several agencies that we don't even represent employees in, and it covered every probationary employee, whether someone was a member, not a member, whether they were eligible or not eligible at all. And so we're fighting again for all federal employees, not just our members, and not just those we represent, but everyone, because it's when he attacks any federal employees, it's attack on all of us. And again, I think that said, it is important that we continue to have federal employees sign up as members. And we have a big push right now for people to sign up on what's called eDues, which is a way to sign up for membership directly through the union as opposed through your agency. And this prevents the agency from dropping you or attacking us through the payroll deduction system.
Okay, I think that's good. Devin, do we have anything else? And I think, Rashab, if you could put your information in there so that people can understand how they can do the e-dues, and be a part of the union so that they can receive information, because a lot of people are interested in, joining. And I think what we would do, I think Tom is going to talk about the RIF process, because there are a lot of people that are talking about RIF, and, should we contact, MSPB? The next speaker is going to speak on that, right, Tom? You're going to speak on that. So thank you so much for that. Anything else, Davin, before we let Rashab go, because I know you have to leave. All right, I think we're good to go. So thank you to Rashab. He's put his information, his email in, so people could take the email and and actually contact him directly if you have any other questions. And there we come to the meat of this, which is a lot of people are having issues as federal workers, wanting to know what are their legal rights. And we have Tom Gagliardo, who I've known for years, and he is a great federal worker, employee, and lawyer. He's been doing this for over 30 years. And let's turn it over to Tom, who's going to advise you all of those, a lot of these questions that people have actually sent to me for the Attorney General. Tom is actually the person that can answer the question, because the Attorney General doesn't necessarily do individual cases. So Tom, I'm going to turn it over to you to do your presentation.
Thanks, Councilmember Blagay. So my name's Tom Gagliardo. I'm an attorney with Gilbert Employment Law in Silver Spring. I have put in the chat contact information. The slides that I'm going to run through right now will be available to all of you. So let me start with a slide presentation. All right, so we're going to talk about retirement, severance pay, unemployment insurance benefits, and what happens in a reduction in force. What are your bump and retreat rights? If I can navigate,
can we get you to share your screen?
Oh, I didn't share it. I'm sorry.
Oh.
My apologies. Okay. Let me figure out how to do that.
Perfect.
Okay. You can see that now. Okay. So first of all, let's talk about retirement.
Start the presentation mode.
Yeah, can you put it in presentation mode?
I don't know how to do that. Can you tell me how to do that?
Yeah, I'm trying to actually see the prompt for it.
You can tell by all the gray in my hair that I can't possibly figure any of this out.
Okay.
It's in the left corner where it says new slide, review slide. There are three. You know what? At the very top in the gray bar, very top, move your cursor up more. Okay, to the left a little bit. This little right there.
Right there. Click on that.
Click that?
Yep. Perfect.
Okay. Now, the next thing you have to teach me is how I go to the next slide.
You can just push the arrow.
Just click, I guess, huh? All right, so let's talk about what I've encountered. First of all, I've talked to many, many federal employees who have been faced with either an offer to accept the deferred resignation plan, or have faced a RIF. And many of those employees are retirement eligible. So if you are retirement eligible, and I'll go through that in just a moment, there are the following basic kinds of retirement. You can find more detail at opm.gov. Just put in the search bar, retirement. Many agencies have authorized voluntary early retirement, or VERA. There are requirements for that, but if you qualify, you may consider taking your retirement, albeit before the planned date, your planned date, but it is available to anybody, whether or not they've been given a RIF notice, whether or not they've been told to return to work. It's available to anybody and everybody. often people ask me, is there any prohibition on my requesting retirement, whether it's early retirement or anything else, at any time? And the answer is no. The agency cannot tell you you may not retire. If you meet the requirements, you can do it. So that's one of the first things we look at. So what is required to qualify for either voluntary early retirement or discontinued service retirement? Discontinued service is when your job has been abolished and there are no other jobs that you can fill. So it's voluntary. Discontinued service is involuntary. If you're at least 50 years old and you have 20 years of creditable federal service, you qualify for either of these types of retirement. If you have at least 25 years of service, your age doesn't matter, you can retire. All right. You must have served in a position covered by OPM. You must be in a position covered by the agency's VERA plan, and you must separate by the close of the early out period. All of this is prescribed at an agency level. Most agencies have given employees notice that they are offering voluntary early retirement. It is only available when when OPM authorizes it and the agency offers it. During the DOGE onslaught, almost every agency, if not every single agency, has had authority and has offered voluntary early retirement. All right. Now, I'm frequently asked, if you retire, whether it's early retirement or anything else, can you keep your health benefits? And the short answer is yes. The requirements are laid out on the slide. I'm not, in the interest of time, I'm not going to go through all of them. The most important thing you need to know is that you must have been enrolled in federal employee health benefits for 5 years prior to when you retire. That is a key requirement. Can you keep your life insurance? Essentially the same answer. All right. Now, how about severance pay? When do you get severance pay? If you're not eligible for a retirement and you are separated from federal service involuntarily, which would be a RIF, okay? As long as it is not separation for cause, you're not being fired for misconduct or poor performance, you are entitled to severance pay. There are the eligibility requirements. You must be employed by an agency covered by this particular law, 5 U.S.C. 5595. Number's not important. Almost everybody in the federal sector is. All right. You must have a regularly scheduled tour of duty and completed at least 12 months of continuous service. And as we've been talking about, you must be removed from federal service involuntarily. How much do you get? For each of the first 10 years of your credited federal service, you get the equivalent of 1 week's pay. And if you have more than 10 years, it's 2 weeks per year. So let's say you have 20 years of credited service. You get 10 plus 20, which is 30. This is if you're involuntarily separated, as would be the case in a RIF. Now, there are also reasons to disqualify one from severance pay. I highlighted the most important ones. If your position is abolished, but you're offered a reasonable reassignment and you refuse it, you will not get severance pay. I always tell people, how is this interpreted? Well, you have to get 2 lawyers, you get 3 different interpretations. If that weren't so, lawyers couldn't make money. So it's a discussion about what is a reasonable offer, but remember that if you are offered an alternative position, you will not, and if it's deemed reasonable, you will not be entitled to severance pay. Here's the other big disqualifier. if you can get an immediate annuity, if you can retire immediately and collect your benefit immediately, you don't get severance pay. So it's one or the other. So the Attorney General mentioned that certain things have to be done if a reduction in force is conducted in accordance with law. First thing is you have to have 60 days notice. Secondly, the agency has to define a competitive area. What is that? It's the organizational and geographical area set for RIF competition, which we'll talk about in 1 second. So for example, it could be the headquarters at the Food and Drug Administration in Silver Spring. It could be the Social Security headquarters in Woodlawn, Maryland. Okay, so the first thing is there's a geographical and organizational limit. It is usually narrower than the whole agency, of course. It might be, for example, Social Security headquarters, Woodlawn, Maryland, Office of General Counsel, Office of Disability Review, whatever it might be. Then within each area, the agency groups interchangeable positions into what they call competitive levels. Now, I'm going to go into this in a little bit of detail, but I want to say something that I believe is important. Given the magnitude of the reductions in force and the way competitive areas have been defined, in many, many cases, this is meaningless because there will be no available positions in which one can bump and retreat. I'll explain those terms in a second. But when USAID is shut down and almost in its entirety, when the Federal Mediation and Conciliation Service is shut down in almost its entirety, when the Department of Education is cut in half, you're going to find that these niceties in the law are nullities in reality. All right. Now, one is rated on 4 retention factors. They're outlined here in the slide. Are you career conditional, indefinite, temporary, or term employees? Veterans get a preference. How much creditable federal service do you have? And what are your performance ratings like? Based on those factors, there's a retention register that's compiled, and you're ranked according to how you've been rated in accordance with the factors. All right. I'm not going to go into these details. These slides, as I mentioned before, are available to everybody. All right, bumping. So bumping means displacing an employee on a different competitive level who is in a lower tenure group or a lower group subgroup within your own tenure group. Make it simple. If you have more points than somebody else, you can bump into their job. Okay, you can bump them out of their job, maybe is a better way to put it. Retreating means displacing an employee with less service within the released retention group. Okay, somebody asked this in the chat. So if you've been separated, fired, downgraded, or furloughed, laid off, riffed, however you want to, whatever word you want to use, for more than 30 days, by virtue of a RIF, you have a right to appeal to the Merit Systems Protection Board. All right. What kind of issue can you raise there? That the agency didn't follow the RIF regulations that we just talked about. You have 30 days to file that appeal. My law firm, Gilbert Employment Law in Silver Spring, and I put the contact information in the chat, is handling these kinds of cases, either on an individual basis or in some cases on a collective or class action basis. That's a bit of technicality, legal technicalities you don't have to worry about. Know that if you are downgraded or furloughed or permanently separated from federal service, you have the right to appeal to the Merit Systems Protection Board. All right. Now, you heard Rishab talk about collective bargaining agreements and the Trump administration trying to disavow their obligations under those agreements. That discussion aside, if you are in a bargaining unit, and let me say that I put into the chat a website maintained by the Office of Personnel Management that will tell you whether or not there is a union contract for a specific component of an agency. If you're covered by a contract, whether you pay dues to the union or not, you have to look at the scope of the grievance procedure. Some grievance procedures say that appeals related to RIFs are not grievable, and other contracts say the exact opposite. They say they are grievable. If your objection to a RIF is a proper subject of your component's grievance procedure, you do not go to the MSPB. You invoke the negotiated grievance procedure. So let's talk for a minute about unemployment. I'm going to talk about Maryland. It's in a later slide, but here's the basic rule. You file for unemployment in the jurisdiction where you worked. So if you live in Maryland but worked in DC, you file for DC unemployment. If you live in DC and you worked in Maryland, then you file Maryland unemployment. It can be done online. Here's how you do it. Or you can do it by a phone call. It's real easy. All right. After you file the claim, assuming that you're granted benefits, you have a continuing obligation, as most of us know, to continue to look for work, to certify what you've done in that week, be available for a possible assignment to a jobs program. Okay, you have to accept. Whoops, I'm sorry, I don't know how to go back now. All right, let me skip over that. Can somebody tell me how to go back to the previous slide? All right, go ahead.
Don't worry. We'll send it out. It's
okay. All right.
Mm-hmm.
So the rules in Maryland and DC are essentially the same. There are some differences. So there are great websites. I've given you the websites in the PowerPoint slides. All right. So here's the one for DC. And again, you can apply online. How much do you get? Well, in the district, the maximum is $444. In Maryland, it's $14 less. It's good up to 26 weeks. Is it a guaranteed 26 weeks? No, because you have an obligation to look for work and to accept a reasonable job offer. So your unemployment would cease at that point. Many people have asked me, given the notices that have been sent out by DOJ, and I think Rushab mentioned something about this, will I be disqualified because they said they're firing me for lack of performance? And the answer is no, you're not disqualified. To oversimplify, you are disqualified if you engage in misconduct or gross misconduct or aggravated misconduct. Those are the categories in Maryland. And being fired because it is alleged that you didn't meet performance standards is not misconduct of any kind. So you're not going to be disqualified for that reason, or so it appears to me. So that's it in a nutshell. There's a lot there. I'm more than happy to answer any questions tonight. I put my contact information in the chat, and I would be glad to answer questions either in the chat or if you call me, I'll be glad to do that as well.
Okay, so I wanted to actually, I decided with this one, we will ask the questions as they were posted in the chat. So the first one is, was severance pay applied to someone who was on probation? Who's someone who was on probation?
I believe it would, yes. Well, there is a minimum employment requirement. As long as you've been there long enough. Some people have 2-year probationary periods. I interviewed 4 lawyers from the Department of Justice they were just 2, 3, 4 weeks shy of completing the 2-year period, I believe under those circumstances, yes, they would have gotten severance.
So the question is, what if you are on the job for 6 months and your probation is 1 year?
I don't think you have enough time in to qualify.
Okay, and I would say a good amount of people who are on probation are on 2-year probation. So if they are doing, so the question is, do you get severance if you're before your probation is done? And the answer is no.
Depends how long. If you're on a 2-year probation, but you've already been there for a year or 18 months, you may well. Let me check something while you're asking me that.
Okay, yeah, we want to check that. I do believe
I don't want to give out any false.
Right, I
or
do think there's a
incorrect information.
limitation on severance if you are on probation. But I do think we want to get clarity on that. So if you could just look that up and let people know, this would be good. But that is a really good question. And the question is, your federal agency is in Virginia. Do you file for unemployment in Virginia? And the answer is yes. You file where you work.
Okay.
You file where you work. Okay, go ahead.
This confirms what I said.
Mm-hmm.
Here's the, I'm going to share my screen again.
Mm-hmm.
Okay. Completed at least 12 months of continuous service.
Okay, so it has to be 1 year.
1 year.
The question is,
if you're on a 2-year probation, you may have your 1 year in, and yes,
right.
then you would get severance. But you're only going to get 1 week of pay, because the amount of severance is the direct function of how long you've been employed.
Okay, so that's good. And the outline of how much each person gets paid per week for unemployment, that is before taxes, right? So do people understand that is before taxes?
That's correct.
Okay, so so you all do know that. If there's incorrect information on a RIF notice, such as they said performance numbers, but that probably is years of service or things like that. I think you would take that up with OPM. If you do have a issue with any of the information that's given to you by your and I'm sorry because I'm like jumping in because I used to do this work.
No, that's
too.
okay. Please do.
You would go to any incorrect information on your notice. You would contact OPM to make sure that it is addressed, because most of the RIF would do years of service. You want to make sure that that's right, because that does determine your RIF.
In the first wave of probationary terminations, it was said you're being terminated because you're not meeting performance standards and your function no longer serves the mission of the agency, or some such language. That was untrue in virtually every case. There were people who had just gotten outstanding performance evaluations. In terms of unemployment, they're not going to disqualify, in my opinion, they're not going to disqualify someone because they got such a letter. Because again, even if it were for lack of performance, that's neither misconduct nor aggravated nor gross misconduct.
Now, this question, Tom, to follow up, if someone does get this letter that does have that, should they go and probably file for unemployment? And if they get denied, they can call your office?
We don't do unemployment cases, but
okay, I know some of the people who do.
If somebody wants to do a consultation, we will certainly advise them. There is an excellent website for the Maryland Department of Labor Licensing and Regulation that handles unemployment. There's more there than anybody ever wanted to know. And there is an appeal process, and we would certainly provide guidance and assistance for somebody. I don't think you need a lawyer for that kind of appeal.
No, and actually, let me just pull that back. So in the state of Maryland, Dollar handles ours. And so if you do get, but we ask that you get the denial first. If you get a denial from from unemployment, then you can reach out to our office and we will connect you with the Department of Labor in the state of Maryland, which should be able to handle your case. So I doubt if you should that, but if you do, then that would be that could be something that we could address. So also there were some other questions that I want to make sure, because we
Okay.
had a lot of question. So they said that unemployment is requesting SF50 and SF8. These are information you can get from OPM, right? You can get those you can reach out to OPM to get that information, your SF50.
You should ask for your electronic official personnel file too. It should be given to you.
Okay, and so then that's something that you need to let everybody know. That's a good thing. Everybody should know that before you leave, you should get your complete electronic file. That means all of your performance evaluations and all of the information, including your SF50 and all of those. So if you need those documents, do get that before you leave your federal service. But you are allowed to reach out to OPM. OPM does have that information and should be giving it to you. The next question, do I qualify for severance pay if currently receiving military retirement pay?
Ask it again while getting
Do I
military
qualify?
retirement.
Yeah, if you're currently receiving military retirement pay.
Does this individual qualify for what?
Severance pay.
Yes. I don't
Yes,
see,
because
it's not a disqualifier to my knowledge.
right. So military will be different than regular retirement, right? Because you did say in your presentation that if you're receiving some sort of retirement, if you're eligible and receiving retirement, then you don't get severance. If you're actively receiving the annuity of retirement.
I don't mean what you're already collecting for prior military service, but I'm saying if you are in a civilian position and you're entitled to retire immediately under FERS or CSRS, then you don't get severance, you get the retirement benefit. But the fact that somebody is already collecting either retirement benefits or VA disability benefits, in my opinion, does not disqualify them from severance pay.
Okay, that's good. The next question is a little confusing. I would say this, can you receive annuity and unemployment? I don't know what annuity you're talking about, but understand that in order for you to receive unemployment, you would have to be let go or terminated. So you couldn't walk to the unemployment office with a retirement letter.
Yeah, it's a little bit more nuanced than it might appear.
Yeah.
A lot of people who are collecting retirement benefits of all sorts also work, whether it's in the federal government or otherwise. You can't double dip, so to speak, and get unemployment. So, for example, if you do get severance pay, during the time you're getting the severance pay, you cannot also collect unemployment. Retirement is a little more nuanced. So, for example, going back to the prior example of getting military retirement and working a civilian job, I would certainly make the argument that the unemployment is compensation for the lost civilian job.
Which should be separate from military benefits.
Yeah, but I have to tell you honestly, I'd want to look into that more carefully.
Okay. So the next, how long do you keep and this is a good question, long do you keep your health insurance and life insurance once you're RIFed?
If you're all right, so depends. All right, two things. First of all, most retirement entitles one to continue federal employee health benefits. Deferred retirement does not. Voluntary early retirement does, and other forms of retirement also allow you to continue. If you are not retirement eligible, you may still be entitled to what we all refer to as COBRA. It's really something else for federal employees, but you're entitled to continued health benefits at your expense. So you have to pay the entire premium plus a 2% administrative fee. You can do that for 18 months. That is, if you are simply someone who is not retirement eligible, therefore will not continue to get FEHB by virtue of retirement, you may still at your expense get continued coverage.
Okay. And I would say I understand the frustration because Cobra is extremely expensive.
It is
No,
expensive.
it's really even though some people might entertain it, most will not. Um, okay, it says, can I get, but in general, I would say this. So if you get clarify, if you get severance, that means you only get Cobra, right? You don't keep your government benefits like you had
That
before.
that is essentially correct. Yes.
Okay. So just so people understand, when you are getting severance, your health insurance is the offer of Cobra, which requires a monthly fee that can be up to $1,000 or more. But if you are in retirement, if you're retirement, then you're eligible for retirement benefits that does include health insurance, right?
There's some cost to it, but it's far less than the Cobra fee.
Okay. And just to be clear, there has been scares from people that they feel that if they get with all of the attack by Trump that they could lose that they might attack their benefits. And we did tell them that legally they're not allowed to, but I just wanted to make sure that you can address that.
I would say the same thing. I mean, the problem with Doge and Trump is that they are perfectly willing to violate the law. But no, it's these are statutorily, quote unquote, guaranteed benefits.
Right. So they would, in order for them to take it, I think that the Attorney General will actively fight that one. In order for them to take your benefits, it will be a clear violation of law. It says, can I get severance if I work for a government job for 15 years and 5 months and I am 58 years old?
Yes. The answer is yes. If you've been there 15 years, you would get 10 plus 10. You would get 20 years of benefits, 20 weeks of pay.
Weeks of benefit.
And the age only comes in when an agency offers, as they sometimes do, what they call an age enhancement. So they might say, if you're 55 or older, you get a little bit more. But that's age, you have to see what the agency is authorized to do. But everybody who's involuntarily separated, as long as they meet the other requirements, 1 week for the first 10 years, 2 weeks for any years after 10.
Okay, so this is a good question because some people are not aware of it. Can you explain the intent to RIF? So you do, but prior, I think by law, they're required to send you a notice, which is the notice of intent to RIF. So can you explain that so people can understand because they're getting it and they want to know why they're getting it?
All right, well, first of all, as far as I know, in most, if not all cases, none of this has been done. Agencies are to formulate an overall reduction in force plan. That is, the agency is supposed to say, we're going to abolish the following positions. We have reasons to do that. We can do the same. We can execute mission with far fewer people. Here's the number. Here are the positions that we've identified as expendable and therefore that will be abolished. The notice is supposed to tell an employee things like their position is going to be abolished, and here are your retention. Here's the retention roster, and here's how we rated you. And upon that notice, that's when employees can say, well, and somebody put this in the chat. I'm a veteran, but you didn't give me veterans preference. Okay. Or whatever the case might be, or you've defined the competitive area improperly, whatever the challenge might be. So so the notice is supposed to be, here's what we're going to do. If you think we've done anything wrong, you have a right to challenge us. But the reality has been, excuse me, we're just going to do it.
Okay. So the notice of intent is supposed to it's the advance notice you have. So if you received it, then that means you will be RIFed, and you do need to get your documents together, request all of your performance evaluations, make sure you get everything done, make sure you get your SF50 and get ready. And now you know how much, up to 20 weeks, every 1 week per 10 year, 1 week per what years of service again?
1 week for the first 10 years, 2 weeks for any additional years.
Okay, so there you go. And someone says if we get retired through the DSR, can we collect unemployment? I'm not sure what DSR means.
I don't know either.
Okay. Okay, so then somebody said
Disability, discontinued service retirement.
I see. Okay, so now that you know.
So this goes back to the question about what is the effect of receiving any retirement benefit on unemployment. I want to check that one out. Well, I don't want to give any false information.
Okay, all right. So we'll make sure we get back to Katie on that. So they said Treasury is essentially forcing employees into DRP and VERA or VSIP. Do employees who accept DRP or VERA retain full pay and full benefits through the end of the DRP and then retain? Okay, so go ahead. You can go ahead and answer.
I believe the answer is yes. DRP is deferred resignation program.
Okay.
My understanding is that during the period, the period usually ends on September 30 of this year. There are some cases that are extended to the end of the year without getting into that. And during that period, through September 30, the agreements that people are being asked to sign should explicitly say that you're still going to get the same pay, the same benefits, the same amount of credited service for retirement, the same contributions to retirement, the same accrual of annual and sick leave as if you were working, and not in this specialized program.
Okay, that's good. Thank you for that. The next one is if my SCD date is September.
Entry on service date. Whether when their date of hire, to make a long story short.
So their date of hire is September 20th.
Yeah.
But they are not of age of retirement. Okay, so but that should be 25 years. What can they do? Would they still be able to retire if they're not at the age of retirement, but their date started in September 2000?
Yeah. All right. So it depends on the type of retirement you're seeking. You can get deferred retirement as long as you have 5 years in, but that means that you don't collect it until you reach a minimum age. For many people, it's age 57. All right. So if you're 45, you have 7 years of service. You can apply for a deferred retirement, but you're not going to get the benefit until you reach your 57th birthday, 12 years into the future.
Thank you. Okay, so this one, I am a probationary employee that was reinstated and my probationary period ends in 8 days. Will the agency still honor the time frame of probation and move into permanent service? But I think that will be that's up to the agency. Unfortunately, we cannot.
It is. And one would always hope that, 8 days out, there isn't going to be a problem. But I have to say candidly, and I don't want to be sowing unnecessary concern and fear, but I've represented any number of people who 8 days, 6 days before the probation is over, they get fired because the agency knows they don't have to follow various due process requirements. I just want to point out, we do a lot of discrimination work in the firm. It is the fact that you're probationary does not change what needs to be proved. So if you're a probationary employee and you think there's a form of discrimination, whether it's race, gender, age, disability status, or whatever, you have the same rights as a career employee has.
Right. Okay, so the other question that came up, it says, can you address MRA with respect to severance? Did we do that already?
MRA, minimum age for retirement.
Yeah.
I think it doesn't, the
It's
only way.
5 years of service, not age.
Correct.
Right?
Unless the agency is offering an age enhancement. So that means if you're a certain age or older, you might get a few more dollars. But the eligibility for severance is simply that you be in a covered position for at least a year.
Okay.
I've
This is
shortcut
fine.
that, but the details are in the slides.
So if I'm ripped, will that mean that I will not get retirement benefits when I turn 62? So I think this is a good question because do you have to vest when you riff? Like what, with the riff, can you go into that?
If you qualify for retirement when you reach a certain age because you have a certain amount of credited service, the fact that you were involuntarily removed because of a RIF does not diminish or change your right to that retirement. So retirement is the only, I get asked this a lot in a lot of different contexts. Even people who are fired for cause do not lose their retirement. There is a specific law that says you lose your retirement for such things as treason, but it's not for, you've been fired because you never came to work. You were absent repeatedly. You never came on time. And 30% of the time you didn't even show. You're fired, okay? Does not change your entitlement to retirement, which is based on years of credited service and age.
Okay. So when a RIF is effective, do we have to request severance pay or pay off leave accumulated, or is this automatically started by the agency? Okay.
Yeah, it should be automatic, and I'm glad that there's an additional fact in that. An employee is entitled to accrued unused annual leave, regardless of anything else. Again, that would be true even if a person were fired for cause. So accrued unused leave has to be cashed out when you're separated. So
it should be automatic.
For severance, it should be automatic. If it's not done, then you do have, the first effort always should be to write to HR or the supervisor or better both and say, hey, what's going on? If it remains unresolved and you're covered by a union contract, to talk to the union, but certainly to take action. Those monies are an employee's as a matter of right.
And I just want to note the previous person talked about getting the correct information. They said when they reach out to the OPM or the notice of the person that they respond to does not respond. So if you don't get a response, how has that been handled? Is that something your office handles, or what goes on if you don't get a response?
It's a growing problem. And you know what it's the result of? The people that are supposed to receive the request and respond, they've been riffed or they've been put on unpaid leave or whatever the case might be. So we would certainly look into that. But, even though we're private attorneys and we take cases, we strongly support unions. And we tell people that often working with their union is a better way to go than to retain us. So always check with the union first. If you don't have a union, sure, go ahead and contact us. Again, I put the contact information in the chat.
All right. Well, we're getting to the end because we've had a lot of speakers today. And so I wanted to make sure we got to most of this. Can you put your information in the chat and making sure that everybody can contact you if they want to reach out to you so that they can get more information. And if you have any other questions, just please reach out. We tried to answer most of the questions. So I think we were able to get through most. But for anybody who has additional questions, we definitely encourage you to reach out. And we do have one more thing. So thank you so much, Tom, for this. This is really helpful. And I think many people here found it helpful. If you have questions, you definitely can reach out to his office and they will address any of your concerns, and we will definitely send out the slides. So we want to bring Health Connect up because that is one way that can address some people's concern about getting access to healthcare. And we have Takia Threat from Health Connect to talk about what you can do if you want to sign up for healthcare. So we're leaving that for our last speaker today.
Hello, everyone. So my name is Takia Threat. I'm the program manager for the Affordable Care Act program for the Prince George's County region. I work with the Department of Social Services, and I partner with Maryland Health Connection to bring affordable resources to you all. So I just wanted to let you all know that if you have just experienced a job loss, then that you are considered for a special enrollment period, because anything with what we call QHPs, Qualified Health Plans, the open enrollment period is from November the 1st to January the 15th. But if you have lost your job, you have 60 days from the date of losing your job to enroll in health coverage through Maryland Health Connections. So all the plans cover essential health benefits like doctor visits, prescriptions, emergency care, mental health services, and more. And 9 out of 10 people who enroll under Maryland Health Connection receive some sort of financial assistance to help with that, with the cost of premiums in the plan. So the coverage would start, so if you enroll between the 1st to the 15th of the month, coverage would start the 1st of the following month. And if you enroll between the 16th and the last day of the month, then coverage would start the 1st of the second following month. So if you sign up, let's say, select your plan July 16th, then your coverage wouldn't start until September the 1st. So not the following month, but the month after that. If you had health coverage through your job, your company may offer you the COBRA. I know that that was talked about earlier. So this is an opportunity to continue your current health coverage, typically up to 18 months, as stated earlier, at an increased personal cost. But I wanted to let you all know that that is not your only option. So you have 60 days to enroll in COBRA, giving you time to explore other options. If you choose to take COBRA, you may not be able to switch to the marketplace until your COBRA ends. So on the Maryland Health Connection website, there is a Get an Estimate tool to help you compare what your plan would be versus the COBRA plan that's package that is sent to you all. If you already enrolled in coverage through the COBRA, you can wait for the enrollment period to open up in fall, which is November the 1st, or you can wait till your COBRA to expire. If those who do not have any income, so your household, and when I say household, those on your taxes, if you have a decrease of income, you may be eligible for Medicaid. Everything is a case-by-case situation, depending on the household income, the size, and more. So if you wanted any information on that, or if you wanted to explore your options to ask questions, we have certified navigators for in-person assistance and over the phone. And our phone number is 301-927-4500. And we can also, again, enroll you over the phone so you do not have to come to our offices. The office that we do have at the moment is the Department of Social Services office, and we are located at the Landover office, the Hyattsville office, and the Temple Hills office. And then you can also email us at pgc.healthconnect@maryland.gov.
All right. Well, thank you so much. You got a couple of praises in the chat too. So thank you for some great work. If you could put the information in the chat so that everyone will be receiving this information, I would encourage you to consider Health Connect because COBRA is extremely expensive. Well, thank you all so much for joining us on this recording today. The question is whether this recording will be available. Yes, it is already available on YouTube, and I would ask my staff if they could post the link of the thing. We will actually send it out. If you signed up, you will receive it, and we will have it, but it has been recorded and it is currently on YouTube right now. So if you want to send it out, we are going to send it out to everyone, and then you will be able to share it with those that you know And we definitely thank you all so much for coming out today. I think this was wonderful information. I just want to thank our Attorney General, Anthony Brown, for taking the time. Thank Rashab from AFGE for taking the time. And thank you, Tom, for giving a great presentation so that our residents will know their rights and what they can do. Thought it was great information. I myself learned quite a bit from everyone here today. But we do have the link for the meeting is actually already out. Ayana, are we able to share it in the chat? If people want to just share it with people, are we able to just put it in the chat? Hold on, I'm gonna give you Sonia. I'm actually gonna
I can get it. It's actually on the
yeah,
um,
but I'm gonna
newsletter and the Zoom link email that they sent as well.
yeah, Sonia, if you can go ahead and post that link that I put it in there. If you could put that in the chat, that would be great. And then we will send it out also so that everybody will be able to get this information. And I do appreciate, we do understand, and I just want to tell you from my office, if you have been laid off and you have not found a job, we are going to be doing a small fair and providing food and services for those who have been laid off. So we do want to get that. If you do reach out to our office, the information has been placed in the chat. And then we will be providing support next month. And we're getting the day, but we're going to be reaching out to people. So if you've been laid off, you haven't gotten a job yet, and we, and I know people, it's a sadly to say we are in a rough time right now, but we are going to get through it. And when we will look back, but we're trying to provide you all as much as support as you can, as much information. I will say that I open you all to reach out to me if you have questions, because honestly, I came up with this idea of this forum because of all the people that reached out to me complaining that they haven't, that they wanted to know their rights. And that's why we came up with this idea. And it actually was very helpful. So thank you all so much. And you all have a good night.